Yes. Good evening, everybody. I, Dr. Meenakshi Kalra, welcome you all on behalf of the SCAORA to this lecture series. Today, we have all gathered here for one of the important topics on constitutional law for the leading cases in the upcoming SCAORA AOR lecture series 2025. We have the honor to have with us today Senior Advocate Dr. Menaka Guruswamy. We welcome you, ma'am, and we are thankful to you for taking out time. Ma'am will deliver lecture today on constitutional law in leading cases. We are showcasing live on YouTube. If anybody has any questions, the same may be put in the chat box and the same will be taken up in the end by ma'am. I now request our president to kindly preside with the session.
Good afternoon, Dr. Guruswamy. Welcome to our show and all the candidates who are there anxiously waiting to hear you. The topic is extremely important, constitutional law, and you bring a great blend of the finest of legal education. You've been a professor, you studied at Oxford, Yale, and Harvard. So you will have to bring all your experience here to guide our young, anxious candidates. And I'm very sure we are looking forward to a great lecture from you. Thank you.
Thank you, Vipin. Thank you.
I would now start with introducing ma'am. It's my distinct honor to introduce to you an eminent legal luminary, Dr. Menaka Guruswamy ma'am. With a distinguished career spanning several decades, Guruswamy ma'am has made significant contributions to the Indian legal system. Dr. Menaka Guruswamy, a senior advocate, was designated in the Supreme Court of India in 2019. She focuses on complex litigation cases. In her private law practice, Guruswamy ma'am practices commercial and criminal law. She acts as a lead counsel in high-value commercial cases, including those involving government tenders, bankruptcy law, and securities law. Ma'am regularly represents several multinational entities and public sector companies, including Reliance Industries, Bloomerang, the Modi Group of Companies, Unitech, and 3C Shelters. Ma'am acts as an Indian law expert in courts outside India, including most recently in the Davis versus Air India case before the courts in Montreal, Canada. She's also been retained by foreign law firms to advise on FCP and money laundering cases against their client. She's actively appeared and advised on multiple cases involving allegations of money laundering and corruption law in India. These include the Delhi excise case and also the AUKUS Westland helicopters case. She's also argued before the Indian Supreme Court in the Vijay Mandalal Chaudhary, the constitutional challenge to India's money laundering law. She also represents both public and private corporations in appeals against arbitral awards before the Delhi High Court and also Supreme Court of India. Ma'am is presently a trustee of the Rhodes Trust, Oxford, UK. She's also a former Rhodes Scholar, having secured a doctorate in law and master's in law from Oxford University. She has a master's in law from Harvard Law School and a BLLB from National Law School, Bangalore. Ma'am started her practice in 1997 in the chambers of Mr. Ashok H. Desai, the then Attorney General of India. She later practiced merger and acquisitions law in New York and as an associate at Davis Polk and Wardwell. She is admitted to the bars in New York and in India. In her public law practice, Guruswamy ma'am has argued in some of the most complex and high-profile disputes before the Supreme Court of India. She's been also regularly visiting the Yale Law School as a faculty, Columbia Law School, and also the New York University Law School of Law. Over to you, ma'am. I would request now to please start with the lecture.
Thanks a lot, Meenakshi, and good afternoon to all the aspirants for the Advocate on Record exam. I'm sure you will all do very, very well, and we look forward to welcoming many of you as AORs to the bar. Today, to kick off the constitutional law segment of these lectures and of your curriculum, we have a lovely set of 6 cases chosen by SCAORA to kickstart this segment of constitutional law. And those 6 cases are actually wide-spanning. Janhit Abhiyan, which speaks to affirmative action in the context of economically weaker segments. Kaushal Kishore, which speaks to freedom of speech, and 2 ministers making controversial remarks. In re Article 370 of the Constitution, which pertains to the abrogation of Article 370 specific to Jammu and Kashmir. The fourth case is the Association for Democratic Reforms versus the Union of India, or the electoral bonds case, which the Supreme Court heard. The fifth case is Aligarh Muslim University, which speaks to minority institutions. And the sixth and final case is a service law case, which implicates Article 14, Tej Prakash Pathak versus the High Court of Rajasthan. All six cases are contemporary Indian constitutional law. They are decided and the judgments released in the last 2 years or so. So they give you a flavor of the thought processes of the Supreme Court, if you will. So let's start off with the first case, which is Janhit Abhiyan versus Union of India, which is a case that is about EWS reservation, right? It's 2023 5 SEC 1. This is a 5-judge bench decision with Justices Maheshwari, Trivedi, and Pardiwala forming the majority, if you will. It's a 5-judge bench decision. And the then Chief Justice, Lalit, and Justice Ravindra Bhatt dissenting. It's a judgment delivered in November of 2022. And the real big question that the judgment, so the formal legal question that the judgment discusses is whether the 103rd Constitution Amendment can be said to breach the basic structure of the Constitution. And the 103rd Constitution Amendment essentially amends Clause 6 of Article 15 and Clause 6 of Article 16 of Part 3 of the Constitution, right? And the majority believes that this Constitution Amendment does not, in fact, breach basic structure, whereas the minority, with the Chief Justice in minority, which is a very unusual event for a Chief Justice of the Supreme Court to be in a minority, in fact said that, along with Justice Bhatt, said that it does breach basic structure. Now, Articles 15 and 16, of course, as you know, 15 discusses the prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. So this is a the non-discrimination clause of Part 3 of the Constitution. It is also a clause which, by subsequent amendment, enables the state to make special provisions for educationally and socially backward classes of citizens, or for scheduled castes and scheduled tribes in Article 15. And Article 16 speaks to equality of opportunity in matters of public employment, another Part 3 provision. And of course, it also does not prevent the state from now making special provisions in favor of economically weaker sections of citizens, subject to a maximum of 10% after this case. So this is a very unusual and interesting case, because as we have traditionally understood reservation, we have traditionally understood that in the context of initially and originally caste, scheduled tribe, other backward classes, and then subsequently women. And now to this segment is added economically weaker segments of society. So this is an economic criterion that is the formal class that comprises it. So this is a very important new interpretation of the Constitution, if you will, which this 5-judge bench decided to rule upon, and is split with 3 judges finding that the executive and parliament can, in fact, then pass this 103rd Amendment, and the minority which felt that it offends basic structure. Now, what is this case all about outside of this kind of brief summary? This case essentially meant that could the state, capped at 10%, have reservation for economically weaker sections? Now, what is interesting about the majority's decision is that the majority consistently uses the frame of affirmative action, which to my mind is quite different from reservation, but be that as it will, I'm going to first tell you what the case says, right? So the case actually hits very distinct points in the context of the creation of constitutionalism, right? So one, it says that the majority says that Parliament has the power under Article 368 to, of course, amend the Constitution subject to the basic structure doctrine. Now, basic features of the Constitution, this is all in para 94 if you're making notes. Basic features of the Constitution is not equivalent to the basic structure of the Constitution. The basic structure, according to the majority, is a sum of the essential features of the Constitution. And I should tell you that this class will run for about 45 minutes or 1 hour, or if anyone's getting bored, then you should send exclamation marks into the chat box. I've also been instructed not to crack any jokes, so I'll keep those to a minimum. Now, some of the basic features of the Constitution, the majority reminds us, is democracy, secularism, equality of status, independence of the judiciary, so on and so forth. Now, affirmative action, the majority tells us in paragraph 89, is an exception to the general rule of equality. The state, in para 89, the court says, is tasked with the duty to effect substantive equality, which is implemented by affirmative action. The duly recognized form of affirmative action is compensatory discrimination through reservation and the quota system. So Articles 15 and 16, which I gave you a brief idea about, were crafted carefully to be enabling provisions in para 19.7. This is what the court holds. They were worded, according to the court, to confer only a discretionary power on the state to obviate the inequality faced by the downtrodden, para 97. Now, Justice Pardiwala, you'll note, accepted the view that an enabling provision like these under Articles 15 and 16 cannot violate basic structure. Justice Bhatt, interestingly, dissented on this. Now, reservation, the majority hold, is an exception to the general rule of equality and cannot be regarded as such as an essential feature of the Constitution, which cannot be modulated to benefit an otherwise excluded section of society. So presumably then the court feels that new layers can be added to these quote-unquote reserved categories, which traditionally otherwise spoke to caste, moved on to include women, and now moves on to include EWS. The majority in para 106 reminds us that our Constitution employs the word economic more than 30 times, most prominently in the preamble. The preamble, and I'm sure many of you know I love reading the preamble out, so I'm going to read it out in any case. The preamble says, "We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, liberty, equality, and fraternity." Now, justice is of three kinds: social, economic, and political. And this presumably is what the majority refers to when it discusses the preamble. Other instances that the majority gives of economic equality, inequality, and economic justice is Article 38 of the Constitution, which speaks to economic justice, Article 39A, which speaks to legal aid for economically poor people, Article 46, which speaks to promotion of economically weaker sections, Article 243, G and W, which speaks to economic development to be undertaken by local bodies. Now, the majority also reminds us at paragraph 107 that our jurisprudence supports making provisions for tackling economic inequalities in accordance with Article 22 of the Universal Declaration of Human Rights. And at paras 108 and 112, the Supreme Court's observations, including in Minerva Mills versus Union of India, is reflective of the fact that substantive equality envisaged by the Constitution is inclusive of economic justice alongside social justice. The preamble, part 3 and part 4 per the majority seek to make economic rights a meaningful reality by enabling states to effectively address the discrimination and exclusion faced by economically weaker segments. And for that matter, every affirmative action has the sanction of the Constitution, para 115. Now, per Justice Dinesh Maheshwari, the economic criterion as a basis for affirmative action does not violate the basic structure. Now, Justice Maheshwari says that existing judgments, and this is at para 127, which only dealt with the pre-amended versions of Article 15 and 16, could not be read to exclude the state's power to make affirmative action qua a class which only, and this is very important, which only suffered from economic limitations. And this is para 127. And if there's any paragraph you should mark in this judgment, it is this paragraph. So I'll read it again. Existing judgments per Justice Dinesh Maheshwari, which only dealt with the pre-amended versions of Article 15 and 16. So this is prior to the 103rd Constitutional Amendment, could not be read to exclude the state's power to take affirmative action qua a class which only suffered from economic limitations, meaning that the state could take affirmative action vis-a-vis a class which only suffers from economic limitation is a shorter way of writing this. Past decisions, he says that where reservation cannot be claimed solely on an economic criterion, only applies to the classes covered under Article 15.4, 15.5, and Article 16.4, paragraph 128. Article 46 of the Constitution, which lays special emphasis on socially backward classes, cannot be read narrowly. The Constitution is intended to be an enduring instrument, and its content has a significance which varies from age to age. It is a living organic thing which is required to meet the current needs and requirements of the time. This is paragraph 131.1. Finally, the majority also says that a simple reading of the headings with the contents of Article 46 is sufficient to establish that other weaker sections is disjointed from specific weaker sections emphasized by name, scheduled caste, scheduled tribe in the provision. Thus, the expression other weaker sections cannot be read to refer to socially weaker sections, but disjunctively refers to the economically weaker sections as well, paragraphs 131.2 and 3. Now, Justice Pardiwala, who writes the concurring judgment, in this case, says that the 103rd Amendment, and this is paragraph 294, the 103rd Amendment signifies the intent to expand affirmative action to hitherto untouched groups who suffer from similar disadvantages, such as OBCs competing for opportunities. If economic advance can be accepted to negate certain social disadvantages for the OBCs, he's referring to the creamy layer concept, the converse, according to Justice Pardiwala, would be equally relevant. And this is para 294. Now, the exclusion of other socially backward classes is not a breach of basic structure per the majority again. That is Justice Dinesh Maheshwari writing. The exclusion is inevitable, he says, for the true operation and effect of the economically weaker sections reservation schemes. He also says that other socially backward classes are already provided with affirmative action by the existing provisions of Articles 15 and 16, and there is no need to extend to them another benefit in the affirmative action carved out for other economically weaker sections, especially when the quota earmarked for them is not depleted in any manner. Now, in paragraphs 144, the majority is also saying compensatory discrimination by its very nature would be exclusionary to achieve its objective. Classes who are already recipient of compensatory discrimination cannot justifiably raise the ground that they are excluded from the benefit of another set of compensatory discrimination. Even if the amendment alters existing equality principles, it is only a moderate abridgment to achieve the valid purpose of socioeconomic justice as enshrined in the Constitution. Now, Justice Bela Trivedi, concurring in her opinion, writes that the exclusion of other classes from the 103rd Constitutional Amendment is not violative of basic structure, since it creates a separate class with a reasonable nexus to the object sought, i.e. economically weaker sections seeking EWS reservation, which does not impede or overlap the other reservations provided for classes under Articles 15.4, 15.5, and 16.4. And finally, Justice Bhatt, dissenting, says that excluding socially backward classes from the ambit of EWS reservation is an exercise of treating the socially backward as quote-unquote more fortunate. This is para 509, and you may mark this. There is no intelligible differentia, according to him, between economically backward and socially backward. Neither is there any rational nexus between that distinction and the object of the amendment, which is to eliminate poverty. This is paragraph 515. The exclusionary clause, he says, strikes at the heart of the Equality Code and breaches the basic structure of the Constitution. This is paragraph 529. The question pertaining to the 50% cap or limit on reservation should be left open, since a finding on the same would impact pending litigation in the matter of the 76th Amendment of the Constitution without effectively hearing the same. And this is something else that Justice Bhatt dissents with at paragraph 609. And he says also that permitting the breach of the 50% cap becomes a gateway for further infractions whereby the right to equality could be reduced to the right of reservation. This is paragraph 610. So the dissenting's conclusion is at paragraph 622, and the majority's conclusion is at paragraphs 184. Now, it's a very interesting case, judgment, reported in 2023. To my mind, it has three important features that just struck me when I was reading the case. One, clearly this idea of reservation, which is in the origins of the Constitution, which speaks to caste, it's slowly expanded to women, but now bringing in this idea of economically weaker segments, whereas originally reservation was understood to speak to the need and a constitutional commitment to increasing representation. The conflation of the majority of affirmative action with reservation is, in fact, to my mind, quite interesting, because it's not clear to me that that is how the Constitution intends reservation to be interpreted. But to move from the need for representation to the need for the economically weaker segments of society is in fact a new trajectory of Indian constitutional law. We may agree or disagree with it, but certainly Janhit Abhiyan is a new direction that Indian constitutional law is being taken. Again, it's a 5-judge bench decision. Now, I'll quickly move on to a very interesting case, which takes us from reservation and affirmative action to freedom of speech. And this is the very interesting case of Kaushal Kishore versus State of UP, 2023 for SCC, page 1. It's again a 5-judge bench decision with Justice Ramasubramanian writing for the majority that comprises himself, Justice Abdul Nazir, and the present Chief Justice, B.R. Gawai, with Justice Bopanna concurring and Justice Nagaratna dissenting. It's a judgment delivered on the 3rd of January, 2023. And this is a case where the key questions that are asked is whether the grounds specified in Article 19.2, in relation to which reasonable restrictions can be imposed on the right to free speech, are exhaustive, or can these restrictions on the right to free speech be imposed on grounds not found in 19.2 by invoking other fundamental rights? And the majority find that the grounds specified in Article 19.2 are exhaustive. This is very important. And additional restrictions over and above Article 19.2 restrictions cannot be imposed. Now, the other key questions with the judgment asks is, can a fundamental right under Article 19 or 21 of the Constitution be claimed other than against the state or its instrumentalities? The majority says yes. Whether the state is under a duty to affirmatively protect the rights of a citizen under Article 21 of the Constitution, even against a threat to the liberty of a citizen by acts or omissions of another citizen or by a private actor. And the majority says yes. What is interesting about the majority on these 3 counts is that they are extending the application of fundamental rights and the protection from arbitrariness and actions that can be taken to be an infraction of fundamental rights to horizontally. So typically, as we've understood part 3, is these are vertical rights, right? So the state offending the fundamental rights of the citizen. But when you take it horizontally, and again, this is a conception that was applied earlier by the South African Constitutional Court, you'll see that it means it could be 2 individuals. What is this case about? This case is about 2 controversial statements made by 2 separate ministers in 2 different state governments. And those were the facts that were the catalyst for this case that ended up before 5 judges. So the real issues in the case are, can a statement be made by a minister that is traceable to any affairs of the state or for protecting the government be attributed vicariously to the government? The majority says no. So the principle of collective responsibility does not apply when an individual minister makes individually controversial statements. And 2, whether a statement by a minister inconsistent with the rights of a citizen under Part 3 of the Constitution constitutes a violation of such constitutional rights and is actionable as a constitutional tort. The majority again says no. Now, for your exam, I suspect this case will come up in the context of 1, horizontal and vertical application of rights, because it's unusual for that reason. And 2, it may come up on this in the idea of collective responsibility. What is collective responsibility, and can collective responsibility be imposed on speech or perhaps other actions of an individual minister, right? So it's a lovely, very interesting and rather unconventional free speech case, because it speaks to collective responsibility, which is again, a concept within parliamentary democracy, and speaks to separation of powers and parliamentary governance. And also about how you interpret the restrictions that Article 19 places upon free speech of citizens, right? So the facts that are thrown up is in one of the criminal petitions that eventually results in the Constitution Bench hearing this case, is a young girl and her mother are gang raped on the national highway. And a minister from Uttar Pradesh makes a statement saying that this is a political conspiracy against the UP government. So that is one statement. And the second statement is a minister from Kerala who also makes a statement which is highly derogatory of women. So these 2 statements are tossed up and are the catalyst for this case before a 5-judge bench. Now, let's look at how the court deals with, firstly, theoretical constitutional law, right? So what are the reasonable restrictions that can be imposed under Article 19.2? Now, I'm going to read you Article 19.2 because it's very, very important. Article 19, of course, is the right to freedom, and 19.1a is that all citizens shall have the right to freedom of speech and expression. 19.2 is the restrictions on this freedom of speech and expression, which is not unparalleled, not unfettered, but subject to these restrictions. And it says nothing in subclause A, which is 19.1a of clause 1, shall affect the operation of any existing law or prevent the state from making any law insofar as such law imposes reasonable restrictions on the exercise of the right conferred by the said subclause in the interests of sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation, or incitement of an offense. Right? So what does the majority say? The majority says the judicial history of Article 19.2 reflects the deliberations which went into the articulation of 8 heads of restrictions, which save all existing laws and enable the state to make laws in restriction of free speech. So this is paragraphs 29 to 31, right? And it says that the restrictions under 19.2, this is very, very important. This is paragraph 33. The restrictions under Article 19.2 are exhaustive and comprehensive enough to cover all possible attacks on any individual, group, class of person, society, the court, country, and the state. Any restriction, and this is very, very important, any restriction beyond the four corners of 19.2 is unconstitutional. Paragraph 33. And if there's one paragraph you'd like to mark in this judgment, it is this, right? So now the majority also says in paragraphs 45, 46, etc., that additional restrictions on the right to free speech cannot be imposed by invoking other fundamental rights. So point number one that the majority makes, reasonable restrictions under 19.2 are exhaustive. Point number two, the majority makes, additional restrictions on the right to free speech cannot be imposed by invoking other fundamental rights. And it then discusses case law that on free speech that enables it to come to this conclusion. And per the majority, now this is the third segment of the judgment, which is important, and I'm assuming presumably in the context of your exam, which speaks to vertical and horizontal effect, right? So this is the second big thematic question that the judgment discusses. So the judgment says, per the majority, the question is whether Part 3 of the Constitution has a vertical or horizontal effect. Whenever constitutional rights only impact government officials, this is paragraph 54, it is said to have a vertical effect. When they impact relations between private individuals, then it is said to have a horizontal effect. This is paragraph 52. This is the second most important paragraph that you must mark in the judgment. Thus, the question boils down to individual autonomy versus respect for constitutional values of all individuals, right? The majority also says that a fundamental right under Articles 19 or 21 of the Constitution can be claimed against persons other than the state or its instrumentalities. This is very important. This is paragraph 83 of the judgment, right? Interestingly, paragraph 82 speaks to Justice Puttaswamy versus Union of India, where the Supreme Court observes that a fundamental right was enforceable against the state and a common law right was enforceable against non-state actors in an ordinary court of law. Here, the Supreme Court goes one step further and says very categorically, it's not just a common law right, but it's saying at paragraph 83 that a fundamental right under Articles 19 or 21 of the Constitution can be claimed against persons other than state or its instrumentality. Now, Justice Nagaratna dissents on this five-judge bench panel. She says that, quote, and this is at paragraph 180, that as far as non-state entities or those entities which do not fall within the scope of Article 12 of the Constitution, and that's the article that speaks to state, are concerned, a writ petition to enforce fundamental rights would not be entertained against them. This is primarily because such matters, she says, would involve disputed questions of fact. So she dissents quite categorically, and this you can mark paragraphs 180 in her judgment. Now, question 3 that the judgment answers is, does the state have a duty to protect the Article 21 rights of a person against the actions of another citizen or private agent? As you can probably guess, that the majority says that the question formulated specifically deals with the concept of personal liberty under 21, which has been expanded through decisions like Kharak Singh, Satwan Singh, and Bandhua Mukti. And therefore, the majority says that the state is under a duty to affirmatively protect the rights of a person under Article 21 whenever there is even a threat from a non-state actor. Now, having said all of this, the Constitutional Court here is not locating its conclusion under horizontal or any of that. The Constitutional Court is actually speaking to this segment of it about collective responsibility of a state for a statement made by a minister. And the majority says that this principle of collective responsibility can be traced to Articles 75(3) and 164(2) as far as the union and the state is concerned. But what the majority says is that, and you'll recollect that this concept of collective responsibility and why we're interrogating it is simply because you remember it is two ministers of two separate state governments who make these controversial and I would say fairly ridiculous and remarks in bad taste, right? And so it is because they are making speech while they are sitting ministers, that this question of collective responsibility, which is a very old traditional principle from common law, is thrown up in this case, right? So the majority says that generally collective responsibility of the Council of Ministers, either to the House of the People or to the Assembly, should be understood to correlate the decisions and actions of the Council of Ministers not to every statement made by an individual minister. So this is paragraph 121, if you want to mark that for your exams. Because here the court is saying that you cannot correlate collective responsibility, which is traditionally in the context of the Council of Ministers, to the House of People or to the Assembly. You cannot correlate it to every statement made by each and every individual minister. So the majority is quite clear that collective responsibility does not extend to speech made by sitting ministers or individual sitting ministers. Now, Justice Nagaratna at paragraph 180 thinks otherwise. She dissents very strongly and says, a statement made by a minister, if traceable to any affairs of the state or for protecting the government, can be attributed vicariously to the government by invoking the principle of collective responsibility, so long as such statement represents the view of the government also. If such a statement is not consistent with the view of the government, then it is attributable to the minister personally. So what is the distinction she's making? She's making a very interesting distinction. She is saying that if the statement X that the minister states, makes, the speech X, the content is X, which the minister makes, if that is attributable as a view of the government, then the principle of vicarious liability will apply, and this will extend to the government of the time. If it is not consistent with the view of the government, then it is only attributable to the minister in question. I would hope that governments don't feel they can make derogatory speech about women, but be that as it may, maybe I'm being optimistic. Anyway, now the last and final prong of this very interesting case is that can you take action against a statement made by a minister if it's violative of Part 3 rights of a citizen? And the majority says that where a minister makes a statement that women are unfit to be employed in a particular avocation, so on and so forth, say that it may reflect his insensitivity to gender equality. It may also expose his low constitutional morality. This is what the majority is saying. But the fact that due to his insensitivity or lack of understanding or low constitutional morality, the majority says that because he speaks a language that has the potential to demean the constitutional rights of a woman cannot be a ground for action in constitutional tort. And this is at paragraph 154 of the judgment. Now moving on from free speech to Article 370 and the abrogation of Article 370 in the context of Jammu and Kashmir. A 5-judge bench decision comprising Justice Chandrachud, then Chief Justice, Justice Gawai, Justice Suryakant, Justice Sanjay Kishan Kaul, and Justice Sanjeev Khanna. So this was a panel of 5 judges, each of whom was either Chief Justice or would be Chief Justice, except Sanjay Kaul, when they heard and decided this case. The factual background, of course, you all know that this is when the president issues constitutional orders number 272 and 273 during the emergency proclamation in Jammu and Kashmir under Article 356(1)(b) of the Constitution. And the effect of these 2 orders issued by the president was that they would be abrogating Article 370 of the Constitution. And Article 370 of the Constitution, which of course, and I'm, in its original form, spoke of temporary provisions with respect to the state of Jammu and Kashmir. This is before abrogation. And before abrogation, it was the powers of parliament to make for the said state shall be limited to, and there were very specific grounds in which parliament could make laws. And after abrogation, which is what is important in the context of your exam, after abrogation, 370 reads as all provisions of this constitution as amended from time to time without any modifications or exceptions. So all provisions of this constitution of India shall apply to the state of Jammu and Kashmir, notwithstanding anything contrary in very specific parts of the constitution. And so, of course, and then, as you know, the state became two union territories, and by the Jammu and Kashmir Reorganization Act of 2019 bifurcated the state into two union territories, and a bunch of writ petitions were filed challenging these two constitutional orders and state action. Now, a lot of the judgment actually traces the constitutional history of Jammu and Kashmir. It's a case I remember well because I was one of the lawyers in the case, arguing the case. So it traces the history and the constitutional origins of this quote-unquote interim arrangement, until the Constituent Assembly of the state was formed. And you can find this historical treatment, in many, many pages, and that is a chunk of the first segment of that case. But since I'd like to keep this lecture to below an hour, and certainly, so I'm not going to take you through the constitutional history of the case of the provision, but you should read it because it's actually very interesting. Now, the 2 or 3 key points that the case decides, right, is one, the constitutional validity of the Jammu and Kashmir Reorganization Bill, right? The then Chief Justice Chandrachud says this, that the Reorganization Bill was challenged for not obtaining the views of the state legislature. This is at paragraph 545. The views of the legislature of the state under the first proviso to Article 3 are recommendatory to begin with. I must tell you that Article 3 of the Constitution of India, which Justice Chandrachud is discussing, speaks to formation of new states and alteration of areas, boundaries, or names of existing states, right? Justice Kaul says that Article 3 gives wide powers to alter the boundaries of the state to Parliament. Even the views of the legislature of a state are not binding on Parliament. And relying on Manohar Lal versus Union of India, it was held that the need to consult the state legislature under Article 3 was dispensed with in the absence of a state legislature. So this is how Justices Chandrachud and Kaul say that the state legislature need not be taken into account, right? So that's the first point. And you'd want to mark paragraphs 545 and paragraph 661 on this point, right? The second prong of the case really speaks to the constitutional validity of Presidential Orders 272 and 273 of the amendment through Article 367. Now, a challenge is made to Constitutional Order 272, which exercised power under Article 371B to amend Article 370 itself without following the procedure laid therein. And this is the question framed in paragraph 376. Now, a long line of cases, and this is something that I'd like to take you through, because a long line of cases, including Shankari Prasad, Singh Dio versus Union of India, Sajjan Singh, Kyoto Holon, were relied on to hold that the substance of a change is more important than its form while interpreting the term modified in Article 370, subclause 3. And for this, you should mark paragraph 402 and 403. And I'll read to you the original Article 370, subclause 3 for your information, so you know what I'm talking about. And Article 370, subclause 3 says, notwithstanding anything in the foregoing provisions of this article, the President may, by public notification, declare that this article shall cease to be operative or shall be operative only with such exceptions and modification and from such date as he may specify, provided that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary before the President issues such a notification. So this is presumably the procedure which is inherent to the original Article 370 of the Constitution as it stood prior to abrogation, right? And so the majority at para 405 says, Constitutional Order 272 purports to add clause 4 to Article 367 and stipulates that the expression Constituent Assembly and the proviso to 373 shall be read as Legislative Assembly. So we just read Article 370 subclause 3, and the majority at para 405, and you can mark this, says that it should be read as Legislative Assembly instead of Constituent Assembly. The proviso to Article 370 subclause 3, the majority says, confers the power to make recommendations to a specific Constituent Assembly. CO 272 changes the language to the proviso of Article 373 in two ways. First, it changes the recommending body from the Constituent Assembly to the Legislative Assembly. And second, it makes a new arrangement at variance with that specific Legislative Assembly. So this is the heart of the case, and this is at para 405. Thus, the majority holds that the terms Constituent Assembly and Legislative Assembly are fundamentally different, and therefore the modification of Article 367 has the effect of substantially modifying Article 373. This would essentially defeat the purpose of having a special procedure for making an amendment to Article 370, and the consequence of permitting such amendments through a circuitous manner would be disastrous. Accordingly, para 2 of CO 272 was held to be ultra vires 370 as it contains a specific provision for its own amendment. This is what the challenge to CO 272 argues. And the challenge to CO 273 argues that the power under 373 subsists independent of the proviso after the Constituent Assembly of the state was dissolved in 1957. If this contention is accepted, then the invalidity of the substitution to the proviso to Article 373 would not affect the exercise of power under the provision to CO 273. Now, the conclusion of the Chief Justice can be found at paragraph 548. And the conclusion of Justice Call can be found at paragraph 663. Now, the conclusions are very categorical. In the context of whether the exercise of the power of the President of India under Article 371D is malified, this is what was held. The principle of consultation and collaboration, and this is all leading up to finding CO 272 to be valid, to the extent that it applies to all provisions of the Constitution of India to the state of Jammu and Kashmir. So CO 272 is valid, and which applies all provisions of the Constitution of India to the state of Jammu and Kashmir. Now, this is the reasoning to it. The principle of consultation and collaboration underlying the provisos of 371D would not be applicable where the effect of the provision is the same as Article 373. Since the effect of applying all the provisions of the Constitution of Jammu and Kashmir through the exercise of power under Article 371D is the same as issuing a notification under Article 373, that 370 ceases to exist, the principle of consultation and collaboration are not required to be followed. The President, in exercise of the power under Article 371D, issued CO 272, applying all the provisions of the Constitution to the state of Jammu and Kashmir. Thus, the concurrence of the government of the state under the second proviso to Article 371D was not required to be secured in the first place. These are all the big conclusions, right? The exercise of power is malified, and this is paragraph 449. Is malified only if the power was exercised with an intent to deceive. Deception can only be proved if the power which is otherwise unavailable to the authority or body is exercised, or if the power that is available is improperly exercised. Since the concurrence of the state government was not required for the exercise of power under 371D, to apply all the provisions of the state, the President securing the concurrence of the Union of India on behalf of the state government is not malified. Thus, CO 272 is valid to the extent that it applies all the provisions of the Constitution of India to the state of Jammu and Kashmir. Now, there's much to discuss about this case, and we can go on and on forever. But unfortunately, I've got maybe 10 to 15 minutes left to discuss 3 more significant constitutional law cases. So I'll keep it moving quickly, and perhaps we could have some questions, right? If you still have doubts. Now, the 4th case I'd like to discuss very briefly and quickly with you pertains to electoral bonds. And this is the Association for Democratic Reforms, the Electoral Bond Scheme versus the Union of India, 2024 5 SCC 1. Again, 5-judge bench decision comprising Justices Chandrachud, Gawai, Manoj Mishra, Pardiwala, and Sanjeev Khanna, right? With Justice Khanna concurring, I believe, with Justice Chandrachud. Now, the particulars of this is that in 2017, the finance minister then proposes an electoral bond scheme. In March 2017, the union introduces amendments to through the Finance Act. And in 2018, the electoral bond scheme was introduced. An electoral bond is a bond issued in the nature of a promissory note akin to a bearer banking instrument not carrying the name of the buyer. This is the heart of it. It's valid for 15 days, and an electoral bond can be purchased by any person and can be encashed only by an eligible political party entitled to receive an electoral bond registered under Section 29A of the Representation of People Act. Now, the question really is that whether the court frames 2 key issues, whether unlimited corporate funding to political parties as envisaged by an amendment to Section 182 of the Companies Act infringes the principle of free and fair elections and violates Article 14 of the Constitution. The court, speaking as one, says yes, it violates Article 14 of the Constitution. And 2, whether the non-disclosure of information on voluntary contributions to political parties under the electoral bond scheme and the amendments to Section 29C of the Representation of People Act, Sections 182(3) of the Companies Act, and Sections 13A and B of the IT Act are violative of the right of information of citizens under Article 19(1)A of the Constitution. And the court again categorically says yes, and therefore the electoral bond scheme violates Article 14, violates Article 19(1)A in the context of right to information of citizens, and therefore presumably is found to be unconstitutional. Now, what are the key segments? What are the big important points of this case that you should probably bear in mind for your exam? That the right to information includes information which would be necessary to further participatory democracy. Para 68, mark this out. RTI has intrinsic constitutional values and is not just a means to an end, but an end in itself. Right? 2, a political party, it's a relevant political unit in the democratic electoral process. Thus, the requirements, the court says at paragraphs 97 and 98, the requirements of disclosure of information about a candidate can be extended to political parties. Very important. Big point 2, paragraph 97 and 98. The electoral bond schemes, according to the court, 5-0, to the extent that they infringe upon the right to information of the voter by anonymizing the contributions and the contributor through electoral bonds, is violative of Article 19(1)A, again, speech, paragraph 107. So you should mark this. So we go from a case where it's a minister making derogatory statements, speech, to a political party receiving anonymous contributions, which violates Article 19(1)A. This facet of speech, which is premised on right to information. Very interesting extension by our Constitutional Court. So another big point that the court makes is that the infringement of the right to information does not does not satisfy the proportionality test. EBS was originally introduced to curb black money and protect donor privacy. The court feels that the right to information under Article 19(1)A can only be restricted based on the grounds stipulated in 1902. The EBS was introduced for curbing black money, the court notes. However, the purpose of curbing black money, very interestingly, is not traceable to any of the grounds in 1902, which we've already read in the previous cases. You can mark this at para 119. And paras 129 to 134 is the heart of the reasoning of the court. A voter, the court feels, should receive complete information about contributions made above 20,000 to a political party in the case of electronic transfer made directly to a political party other than through electoral bonds. A voter would receive partial information, the court says, where a contribution is made through an electoral trust, a trust. There are, according to the court, no regulatory checks on electoral bonds, and therefore electoral bonds fails the necessity test and fails the legitimate goal test, which is curbing black money, and is therefore found to be unconstitutional. Finally, the court also says that the non-disclosure of contributions under the IT Act is unconstitutional. The other important point the court makes is in the context of corporate funding. And this is the last point I'll hit in this case. And you may mark this as paras 186, that the court feels, 186 and 210, the court feels that the ability of a company, 218, the ability of a company to influence the electoral process through political contributions is much higher, the court says, when compared to that of an individual. A company has a much graver influence on the political process. Contributions made by companies are business transactions with the intent of securing benefits in return. And therefore, the court feels that companies and individuals cannot be equated for the purpose of political contributions. Thus, the amendment to Section 182 of the Companies Act is manifestly arbitrary, according to the court, because it treats political contributions by companies and individuals alike, and it permits the unregulated influence of companies in the governance and political process. You can mark paras 222 and 309 as conclusions of the court. Now, very quickly, we're left with two cases. One very important case, Aligarh Muslim University versus Naresh Agarwal, 2024 SEC Online. A quorum of 5 judges, Justices, Chief Justice Chandrachud, as he then was, Justice Khanna, Justice Pardiwala, and Justice Manoj Mishra forming the majority. Justices Suryakant, Dipankar Datta, and Satish Chandra Sharma were dissenting in different ways. The majority opinion is authored by Chief Justice Chandrachud, as he then was. Now, there are 4 key questions that this case deals with, and it pertains to the minority status or the lack thereof of the Aligarh Muslim University. Now, the 4 questions or the key issues that this case deals with is: 1, whether an educational institution must be both established and administered by a linguistic or religious minority to secure the guarantee of Article 30. And the court categorically answers this as yes. Article 30, of course, as you'd all know, pertains to the ability of minorities, the right of minorities to establish and administer educational institutions. 30 Clause 1 says, all minorities, whether based on religion and language, shall have the right to establish and administer educational institutions of their choice. The key words here being the right to establish and administer. So the first question, whether an educational institution must be both established and administered by a linguistic or religious minority, the court says yes. 2, whether Article 30 Clause 1, which I just read, envisages an institution which is established by a minority with participation from members of other communities. Very interesting question. It came up more recently in a challenge to the new Waqf law. And the court in this case categorically says yes. Question 3, whether a minority educational institution which is registered as a society under the Societies Registration Act 1860 loses its status as a minority educational institution. The court categorically says no. And 4, whether the decision of this court in Professor Yashpal versus State of Chhattisgarh and the amendment of the National Commission for Minority Educational Institutions Act in 2010 has a bearing on the questions formulated above. The court categorically says no. Now, you should know the factual background because this case discusses it. I should say the jurisprudential background of this case is a 5-judge bench decision of the Supreme Court in Aziz Basha versus Union of India, AIR 1968, SC 662, which upheld the validity of the 1951 and 65 amendments to the Aligarh Muslim University Act 1920 and observed that it was not a minority institution since it was established by a central government legislation. The amendments removed the statutory role of the Muslim community and gave control to the central government for the administration of AMU. Now, there are two distinct aspects of this case, which you should know about. And I'm going to take just a few minutes because I am running out of time. One aspect of this case is the correctness of the reference order of 2019, because it is a 2-judge bench that refers this to a 7-judge bench decision. And one aspect of this case is, can this referral mechanism that is in place be held to be correct? Now, the correctness of this, now the dissent says that a reference by a 2-judge bench to a 7-judge bench on a settled issue of law is impermissible. And such a reference, according to Justice Suryakant, who's dissenting, para 97, is that it's in the teeth of the Dawoodi Bohra case, the doctrine of predictability. You should know this, the doctrine of finality, the principle of judicial propriety, and stare decisis. Right? That's one aspect in terms of the institutional mechanism. Can a 2-judge bench refer a question to a 7-judge bench? And two, Justice Suryakant says that para 189, you may mark this, that there is no substantial difference between doubting, that's the word doubting, or disagreeing with a judgment of a larger case. Justice Dipankar Datta, also dissenting, says that the reference order is not in accordance with the law. It is not open for a 2-judge bench in Anjuman-e-Rahmaniya to disagree with the verdict of the 5-judge bench, which I just told you about, in Aziz Pasha, and seek this reference. And this is at para 37 of his judgment. Now, the court discusses many things which are well established. The right of minorities to establish and manage educational institutions, para 51, and Ahmedabad St. Xavier's. You can read these initial paragraphs. Very importantly, the court says that the institution under Article 31 must be established and administered by a minority. So it's not or, but it must be established and administered. The court says an institution cannot, and this is para 72, cannot be labeled as a minority institution under Article 30, Clause 1, simply because it is founded by a minority. The community must have the intention to administer it. The second piece is that the enactment of a legislation, this is para 107, the court says the enactment of a legislation to incorporate a university would not repudiate its minority character. So incorporation or becoming a recognized university would impart many benefits. It should not mean that the minority institution would relinquish its rights guaranteed under Part 3. This is para 107. And this is the majority opinion on point. So this is the majority opinion on the issue, the substantive constitutional issue of a institution, one, that it must be established and administered by a minority, and two, that the enactment of a legislation to incorporate a university, in this case AMU, would not repudiate its minority character. This is to be marked at para 107. The court importantly says that the court hearing cases such as this must pierce the veil of the statute to identify if the institution intended to retain its minority character even upon incorporation. This is a very, very important point, para 110. Justice Suryakant dissenting says that at para 190, a university cannot seek protection of Article 30 if the legislature established an institution which promotes other streams of education besides preserving the culture and languages of minorities. and his dissent is at para 190. Right? Apart from this, the other aspect of this decision is that it sets up key indicators of what is a minority educational institution. And this you'll see, Justice Satish Chandra Sharma says that a minority institution must play a minority must play a predominant role to bring the institution into existence. This is at para 169, if it should satisfy the test of 30 clause 1. So who establishes the institution is an important ingredient. Justice Suryakant at 184 says it's a twin test to determine the nature of a minority institution. One, the establishment coming into existence for the benefit of the minority community, and two, administration, de jure and de facto, should be by the minority community. Para 184. Right? Now, eventually, the court sends the matter back to the Allahabad High Court to decide whether AMU is a minority institution or not on the basis of the factors enumerated in this judgment. Justice Dipankar Datta dissents on this point and says that the issue pertaining to the status of AMU should not be left undecided, but should have been decided. So these are the important facets of this judgment. I'm going to make it very quick, and I'm going to end with a service law case, which is the sixth and final judgment and case that I will be discussing. This service law case is Tej Prakash Pathak versus the High Court of Rajasthan, 2025 to SCC1. It's again a 5-judge bench decision, a majority opinion authored by Justice Manoj Mishra. There are two key issues raised in this case. One, whether K. Manjushri versus the state of Andhra Pradesh, 2008 3 SCC 512 lays down the correct law. What does Manjushri say? The rules of a game cannot be changed after recruitment has begun. And the Supreme Court in Tej Prakash Pathak upheld Manjushri, says that Manjushri decided the law correctly, yes, and the appointing authority can devise criteria, procedure, and set benchmarks. But the same must be done before the commencement of the recruitment process. This is para 14, not during, but before. The second key issue and question that the court raises is whether the rules of the game, qua method and manner of making selection, can be changed or altered after commencement of the recruitment process. The court categorically, Justice Manoj Mishra writing for the court, says no, making 2 points at paragraph 65. The recruitment process begins with the notification of the advertisement of recruitment and ends with the appointment of candidates. And two, the eligibility criteria cannot be changed midway unless the extant rule and advertisement permits. Even then, the court says the changes must satisfy Article 14 or the test of arbitrariness. So this is a very classical service law principle. You cannot change the rules of the game during the process. So it starts with the advertisement, and it meets this idea, very fundamental concept of constitutional law, Article 14, which is that to do so would be arbitrary. Say the eligibility criteria, you change it midway through, then to do so would be arbitrary, unless, and this is very important, it would not be arbitrary unless you have a rule or a provision in the advertisement announcing the vacancies, announcing the provisions, saying that the eligibility criteria can be tweaked midway through. Right? So this is the case, which is Tej Prakash Pathak. It deals with the recruitment made by the Rajasthan High Court, which then introduced a 75 cutoff percentage after the process of recruitment had begun. And the appellants argued on the basis of Manjushri versus state of AP. And the reference question was whether the eligibility criteria can be changed mid-process, but the court answers it categorically no, but it can be tweaked if the advertisement allows for this. Right? So this is what is a very subtle variance that is introduced in this case, which is the sixth and final case that I'm discussing. And now I've now gone well over an hour, so I will stop. And I'm not sure if now we should open this up for questions, Meenakshi, or what we should do. I must also say that I do, before I finish this, I also want to thank my two of my chamber colleagues who had prepared this lecture, and really this is all them, Shashwati and Bhumika. So thank you very much, both lawyers at the bar, and clearly they've done a lot of work, so I'm grateful to them. Yes.
Thank you,
Vipin,
ma'am.
Meenakshi, tell me what I should do.
Yes, ma'am. There are three questions which we will start first. Rajesh Kumar has asked that could you explain the horizontal and vertical application of rights?
Yeah. So horizontal basically means individual versus individual. Vertical is very conventional constitutional law, state infracting the rights of individuals.
Thank you, ma'am. The second question has been asked by Indu Kaul. She's asked that will we get the head notes or complete judgments in exam?
I don't know. I am not an
No, only
AOR.
the only the head notes.
Would
Only the head
answer
notes.
it.
Only the head
Only the
notes.
head notes.
Only the head notes are
That's
available.
specially prepared by Supreme Court of India. That's a separate volume which they give the aspirants and they take it back.
An open book, actually.
And the
I have
third,
a question.
yes,
Do you
ma'am.
throw a party for those who've taken the exam, Vipin?
Sorry?
Do you throw a party when you take the exam, when the candidates have taken the exam, Vipin?
We wish them well.
The third,
There's no party, is what Vipin is saying. Yeah.
But
the
the
third and last question is, ma'am,
yeah.
by Mr. Vineet PR. He's asked that kindly enlighten on the answer writing and perspective of the examiner with reference to marking.
Ooh, Vipin, Nikhil, and Meenakshi will answer this question. Very important on marking.
I think the President Sir and Secretary Sir can throw light on this.
Actually, we really don't know how the scheme works, but all the panel of examiners are people of very high integrity and impeachable qualities. So they fix their own. I don't think it is in public domain, the marking system. Just that legal updates, as you know, the topics you've taken, this is the most crucial because this is the backbone of other papers. So if they score well here, it serves them well in the other papers. So I would recommend everybody to do these tests very well.
Ma'am, there's another one question which has been asked is, does the judgment of 5 judges in Janit Abhiyan go beyond decision of 9 bench in Indira Sani, if you could clarify?
You know, I don't think it does, but I also think that Janit says that Sani applies only to pre-amendment 15 and 16. Pre-amendment 15 and 16, Article 15 and 16. So, you know, it really depends on how you interpret the width. Look, Janit Abhiyan, there's many things to be said, which I don't think we should discuss it as prep for the AOR exam. Right? There's many things to be said. There are new concepts it's introduced in constitutional law. But I think that's for a separate conversation, Vipin.
Yes.
Because I don't think it's going to come up in the exam.
And there are a few more questions that have now suddenly come up. The second,
I think I will now, Meenakshi, if it's okay. We're now at like about an hour, 15 minutes in. I'm now going to request.
I'll just take up the question. I'll message you.
Yes, if you could collect them and then pass them on.
Also, ma'am, one last question. Would you be able to share your notes with everybody if that's
Good Lord. You know, these are just like notes specific to, you know, my office, which my colleagues have made internally. I think you'd really be better served if you would read the cases, or if you would at least read the head notes of the cases.
Okay, ma'am. Thank you so
Thank you so much.
Thank you.
Thanks.
So much.
The whole SCAORA
Thank you very much. It's been a great good luck to all the candidates who are taking this exam. I think it's wonderful that you are taking this exam. AORs are, and I say this all the time, they're really the backbone and the soul of the Supreme Court and the practice of law, right? So I wish you all the very, very best, and I'm sure it'll go well. Thank you so much and take care.
Thank you.
Thank you, ma'am. Thank you.